What's up, everybody? Welcome to another episode of Hidden Forces with me, Demetri Kofinas. Today, I speak with Jeffrey Rosen, the nation's most widely read and influential legal commentator. Mr. Rosen is the president and chief executive officer of the National Constitution Center, the only institution in America chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis. Rosen is also a professor at the George Washington University Law School, a non-resident senior fellow at the Brookings Institution, and a contributing editor for The Atlantic magazine. In this episode, we step back from the partisanship and rancor of the marketplace of ideas and appreciate the wisdom and forethought of that 4-page document in which are enumerated the guiding principles by which this republic has stood the test of time. The American Constitution is a living, breathing document whose life force is expressed in the innumerable opinions issued by the courts and debated on by the citizenry of this republic. How do we interpret a document written more than 200 years ago by a handful of white, slave-owning revolutionaries in an age of empire, terror, and technological futurism? How do theories of mind apply to the laws of personhood? How do we interpret the First, Fourth, Fifth, and Sixth Amendments in an age of synthetic news, artificial intelligence, and genetic engineering? And can this enduring document safeguard our liberty, autonomy, and freedom in the digital age? As always, you can gain access to reading lists put together by me ahead of every episode by visiting the show's website at hiddenforcespod.com. Lastly, if you are listening to the show on iTunes or Android, make sure to subscribe. If you like the show, write us a review. And if you want a sneak peek into how the show is made, or for special storylines told through pictures and questions, then like us on Facebook and follow us on Twitter and Instagram at Hidden Forces Pod. And now, let's get right to this week's conversation. Professor Rosen, welcome to Hidden Forces.
Thank you. Wonderful to be here.
I'm very excited to have you on the program. So as I mentioned to your staff, I've listened to your Great Courses series and I loved it. And I have gone through your book, Constitutional Law 3.0. And well, it's actually edited by you. It's actually got a number of really great sort of articles in there from different writers. So it's no surprise that's kind of the area that I want to cover today. But there's sort of two general areas that I'm thinking about. I'm sort of breaking it down in my head, and each of those subdivides as well. One of them has to do with sort of the impact of information technology and this general technological revolution and how that affects privacy, autonomy, agency, and freedom. And the second has to do more with this emergent science in neuropsychology and bioethics, as well as cybernetic organisms and artificial intelligence, and how that affects our notions of personal responsibility and culpability for crimes, etc. Maybe you could start by sort of walking us through the evolution of the law as this sort of organism in the context of technological change, because I think you've done a really remarkable job of doing that, in particular with your lectures, and I'd love to hear maybe you sort of start us on that path for the audience.
Sure. It's such a fascinating topic, and maybe it would be helpful to just take one example, which is the evolution of law as it relates to electronic surveillance. The law began by focusing on physical trespass as a necessary trigger for constitutional protections against unreasonable searches and seizures. The Fourth Amendment says the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And the paradigmatic example of that at the time of the framing was a general warrant, or the writs of assistance, that sparked the American Revolution by allowing the king and his agents to break into the homes of his critics and search for authors of anonymous pamphlets. Basically, the law of trespass defined the contours of the Fourth Amendment for much of the 18th, 19th, and early 20th century. But then wiretapping was invented, and the court had to decide whether a wiretap, which could listen in on conversations without a physical trespass, violated the Fourth Amendment. In a wooden majority opinion, the court said no. Chief Justice William Howard Taft said no trespass, no constitutional violation, since the wiretaps were under a public sidewalk leading up to the suspected bootlegger's office. No warrant was required. In a visionary dissenting opinion, which set the stage for the law of electronic surveillance in the 20th century, Justice Louis Brandeis disagreed. He said that electronic surveillance is even more invasive than a search of someone's home or private diaries because it can invade the conversations of people on both ends of the telephone. Brandeis had in his desk drawer a clipping about a new technology, television, which he misunderstood as a kind of two-way technology. Essentially, he anticipated Skype, but he alludes to Skype and cloud computing in this incredibly visionary passage. And he says in this remarkable dissenting opinion that the progress of science and invention is not likely to stop with wiretapping. Ways may someday be developed by which it's possible, without physically intruding into desk drawers, to extract secret papers and introduce them in court. Advances in the psychic and related sciences, Brandeis predicted, may make it possible to reveal unexpressed thoughts, sensations, and emotions. At the time of the framing, a smaller intrusion, the general warrants, was held to violate the Fourth Amendment. Brandeis insisted that we had to translate the Fourth Amendment so it protected the same amount of privacy in the age of the wires as it did in the time of the framing. Well, the Supreme Court later in the 20th century adopted some of Brandeis's insights, but in a way that inadvertently undermined his central vision. The court in the case called the Katz case in 1967 held that the police couldn't put a wiretap in a public phone booth to listen in on the phone conversations of a suspected gambler without a warrant. But it said that the test for deciding whether the Fourth Amendment was triggered was whether people had a subjective expectation of privacy that society was prepared to accept as reasonable. That sounded like an advance because the court said the Fourth Amendment protects people, not places, and therefore physical trespass wasn't required. But the problem with the expectation of privacy test is that it's quite circular. Our expectations of privacy depend on the amount of privacy we subjectively experience, and as electronic surveillance became more pervasive, our expectations were lowered in a way that correspondingly lowered constitutional protections. So the 70s and 80s are just full of cases of where the court says, well, you have to assume the risk that when you turn over information to a third party, you abandon all expectations of privacy in it. That was a case called Smith versus Maryland. And that led to a dramatic diminution of privacy in an age when many of our intimate thoughts and sensations and emotions are stored in the digital cloud. Well, this is still a contested and open area. The court has, in cases, been willing to translate the amendment so it forbids warrantless searches without physical trespass. In particular, a case where someone was arrested and the court unanimously said that the police couldn't search his cell phone without a warrant because we do have an expectation of privacy in our cell phones. But that, of course, would have involved a physical seizure. Really, the dramatic culmination of this fascinating story may come later this year in the Carpenter case, heard at the end of November, where the Supreme Court will decide whether the police can subpoena geolocational records from our cell phones without a warrant. And that will force the court squarely to confront an issue that it sidestepped in a case involving global positioning system surveillance, namely, can you reconstruct someone's movements in public without a warrant? There's a bipartisan coalition in favor of privacy on the court, so I'm cautiously optimistic that the court will hold that a warrant is required, but whether it will do so narrowly or broadly and precisely what the reasoning will be remains to be seen.
So, Professor Rosen, you're also touching on there, what you mentioned was, first you really brought up the case of John Wilkes, right? That was the first sort of thing that you were describing in terms of what initiated this, or not initiated, but what the framers had in mind when they sit down to write the Constitution and the Bill of Rights. And the first case you mentioned there was Olmsted versus the United States, and you touched on the dissenting opinion by Justice Brandeis. I want to actually read that because I have that written out here, and I want our audience to really appreciate this one particular passage that I really like, and then I want to ask you something. Ways may someday be developed by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home. I want people to sort of think about that a bit, and the reason why is because one of the things I find fascinating, and I want to sort of get to that point in this discussion, is the way in which prior opinions have influenced future cases and the way in which we try to imagine the ways in which technology may be applied going forward. And I want to think about that as we make sort of projections towards the end of this discussion. But having said that, quoting Justice Brandeis there, you often say, what would Brandeis do, I think you say, or yeah, what would Brandeis do? What would Brandeis think? What would he say about where the law has taken us today? What would he think?
Well, I'm so glad you read that passage. It's so prophetic and so worth reflecting on. And Brandeis was right that ways have been developed by which the government, without removing papers from secret drawers, can reproduce them in court. That's what cloud computing is, and it's remarkable how he seemed to anticipate it. I think Brandeis would have been distressed by the court's well-meaning efforts to protect privacy in cases where there wasn't physical invasion, but in ways that made privacy so vulnerable, in particular this so-called third-party doctrine that says that when I turn over information to a third party, I lose all expectation of privacy in it. And I think that he would have felt that this doctrine, which arose in a case called Smith versus Maryland in the 1970s, is not appropriate when it comes to the surveillance of cell phone records or geolocational records or intimate data stored in the third-party cloud, because so many of our intimate thoughts, sensations, and emotions can be revealed by these searches. The second part of the sentence you quoted says, by which it will be enabled to expose to a jury the most intimate occurrences of the home. And that's exactly what the search of cloud data can do, and it can also expose the most intimate thoughts that we have that may be stored digitally. So he would have been alert to the challenge, but on the other hand, I think he would have been happy that there's such a bipartisan consensus among liberal and conservative justices, and by the fact that I think all 9 justices of the court have cited at various times Brandeis's dissenting opinion in Olmsted, which has broad bipartisan support, and he would have applauded creative efforts to translate the amendment in an age of new technology. So he's a prophetic guide, and I hope that the court will live up to his example later this year.
Can you speak a little bit about the proportionality principle as it applies to Olmsted versus the United States? And also you touched on the home there with his dissenting opinion that I read. And could you also talk a little bit about the privacy that is afforded to us by virtue of that decision and the role of the home in being a sort of bulwark for that in American society?
Well, the home really has the highest constitutional protection because it's the paradigmatic example of a constitutionally protected space at the time of the framing. I'm glad you mentioned John Wilkes's case, and Wilkes, as you know, was the British critic of King George who wrote anonymous pamphlets criticizing the king and then stored the printer's proofs in his home. So the king's agents had to break into his home in order to reveal him as the author of this pamphlet, North Britain 45. And based on the outrage against the warrantless search of Wilkes's home and the home of other colonists and Englishmen, the home has the highest constitutional protection. It's interesting that in some electronic privacy cases, the more conservative justices are more willing to find invasions when the home is at stake. So in the Kylo case involving a thermal imaging device that could reveal how much heat was on the outside of the home, Justice Scalia wrote a majority opinion saying that any cutting-edge technology that might reveal information about intimate activities in the home presumptively required a warrant. And since the thermal imaging technology could reveal heat on the outside of the house, which might suggest that the hour of the day that the lady of the house was taking her daily sauna or bath, therefore a warrant was presumptively required. A very resonant image from classical imagery, as Jeannie Suk, the Harvard scholar, has noted. But so that's great that the home has such sacrosanct constitutional protection, but it's not enough in an age when our most intimate thoughts and papers are no longer, for most of us, stored in the home, but stored in the digital cloud or on our Google Docs or on our hard drives.
I wanted to interject with a question, if you didn't mind. What you're referring to is the Fourth Amendment, correct? This is where the home comes up as well in the Bill of Rights?
Yes, and let's quote it. The right of the people to be secure in their persons, houses, papers, and effects. So houses, as well as persons and papers and effects, are the paradigmatic example of constitutionally protected spaces or things under the Fourth Amendment.
So I wondered, when I was reading that, because I actually printed out the First, Fourth, Fifth, and Sixth Amendments, as well as the Eighth, although, and I'm not sure exactly why I did that. I have to sort of think about that.
Why not?
It must have had, there must have been a good reason for it. But in the Fourth Amendment, when I was reading through it, I thought a little bit about secure in their persons. And I thought about the evolution of technology. And, I wonder if you've looked at that amendment and thought about how that might be interpreted going forward.
The evolution of persons?
The evolution of identity. And that sort of comes back to something I mentioned early on, and I'm sort of jumping ahead here, but I mentioned these innovations with respect to artificial intelligence and cybernetic sort of people, as we sort of add appendages that are non-biological. And certainly with respect to artificial intelligence, you may be familiar with these arguments, and particularly in Silicon Valley, around building a theory of mind for consciousness, so that if we get to a place where technology fulfills certain, checks certain boxes, that we have to afford it certain constitutional rights. It may sound bizarre if this is the first time you're hearing it. I can certainly relate to that, but I'm curious if you've heard that and if there is any sort of conversation in the legal community around that. Is anyone looking forward to those types of arguments?
They are. In the collection you mentioned, Constitution 3.0, which Ben Wittes and I edited, there's an interesting piece by Jamie Boyle of Duke Law School about the future of personhood. And Boyle imagines futures genetically enhanced chimpanzees, for example, or dolphins, or even, I think this is his example, not mine, a sort of a sapient sex toy that would seem like a human being but would not have human characteristics and so forth. So, and in this piece, Boyle tries to imagine what the future of personhood might be and basically what a definition of personhood might be. And he offers, as I recall, the example of the Turing test, which is the ability of an enhanced AI object to perform certain tasks to appear to meet a certain threshold of human intelligence. That's just one proposal. There's so many things to say about this fascinating thought experiment, but the Fourth Amendment talks about the right of the people to be secure in their persons, their houses, their papers, and their effects. So, the most obvious sort of originalist thought that comes to mind is that Chief Justice Taney, in his infamous opinion in the Dred Scott case, said that we, the people, were the people who created the U.S. Constitution, and he infamously and historically incorrectly said African Americans were not part of that people. That part of his opinion is discredited, but the part the Supreme Court has repeatedly reaffirmed is that the people refers to American citizens, interestingly. It does not refer even to aliens. And the court has reaffirmed that when the Bill of Rights refers to people, it's talking about citizens. So if you were going to translate the Fourth Amendment so it included artificial intelligence, you could try to persuade the court to overturn that holding, although I think that'd be tough because it's pretty well established. But it appears that even though the notion of personhood may evolve, the question of the people itself at the moment is defined as American citizens. You also would have to ascribe a kind of citizenship to enhanced robots or sapient animals or as you please. So there are a lot of moving parts to this interesting question.
That's very fascinating. I love your answer, and it really resonates with me because I must say, this is the first time I really went through the Constitution in any level of detail. I have no law degree, and really looking at these amendments and trying to think about them, I find humbling, and also in some ways it gives me a sense of confidence around the system because I see the way in which the law has evolved, given all its major imperfections. But I appreciate your answer there. To follow along that thread in terms of looking forward, one of the other things that has come up, certainly on this show, it's something that we talk about given the sort of topics, is the sort of the ethics around engineering and the way in which I sort of shorthand this in my thinking. I call it algorithmic jurisprudence. And I think the most sort of obvious place to look at it and to sort of find it where I think it's easiest to think about is in respect to the engineering of utility functions and values in technology around driverless cars. So you may be familiar, I imagine you are, with the sort of dilemma that engineers face in sort of assessing the probabilities of hitting a pedestrian or the car hitting a pole and figuring out, what's the likelihood of hitting a pedestrian, what's the likelihood of the driver hitting the pole, and sort of what's the distribution there in terms of bodily harm and also in terms of value. Who is worth what? Is a child worth more than an adult? Is an adult worth more than an old person? Certainly the laws in civil court have touched on this, I believe, certainly with you can extract more from a person who is of an age of income production as opposed to a child. I mean, there are these perverse ways of sort of valuing people. Do you think about that at all with respect to the Bill of Rights and how it is that and this touches, of course, on corporate power, right? And the way in which the Constitution protects us from the government much better than it protects us against private corporations. Do you have any thoughts on that at all? The first part and the second part.
It's a completely great question. Just give them each to me separately because I want to make sure I do them justice.
Absolutely.
Well,
so the first one is really the fact that we are entering an age where, in a sense, there's a sort of extrajudicial, people are not being tried extrajudiciously. That is a separate issue. I don't mean to conflate it. But what I mean is that if you're putting a value into an algorithm and deciding sort of what value as a private corporation individual people have, and you're designing cars, that's something that normally the courts would decide after the fact, right? I mean, that entire idea, have you sort of thought of that? Do you have any opinions about that?
It's a really big question. I have not thought about it in any systematic way at all, but you're quite right. You're absolutely right that as driverless cars get up and running, questions of liability for car accidents will have to be rethought. Questions of negligence, intent, reasonable care, all of these right now are premised on the idea of human agency. And once the algorithms of the self-driving cars are taking over, one question is to what degree should the humans be accountable? And then you raise the question of should the authors of the algorithms themselves be accountable? And the common law can impose liability on any party that it thinks will benefit society as a whole. It's often a kind of cost-benefit analysis, and the party in the best position to avoid harm is often the object of liability. So it's not inconceivable you could imagine common law courts or legislators putting liability on Google or whoever is designing the algorithm in order to try to persuade them to design a better algorithm, or they might reach a different balance. But there are just a whole host of really fascinating, really complicated questions. I haven't begun to think about them, but they will keep lawyers, law students, and citizens busy for decades to come.
So then following on that a little bit, I believe that at least one of your graduate students works or worked at Facebook. Is that right?
One of my students at GW worked at Google, and I'm very proud of him. He's heading up their privacy policy, and he's doing a great job.
I say that because I remember seeing, maybe I was thinking of someone else. Someone was lecturing, I believe it was you, and you spoke about this dilemma that some law students, and I believe maybe it was not you, but whoever was speaking said, one of my students works at Facebook, and he tells me, look, I shouldn't be in the position of having to make these decisions. These are decisions that should be made in the court of law. That these are constitutional questions, and I'm being forced sort of in my position, this commercial entity, to make these decisions. Whether it was you or someone else, it was a public statement. I remember it was part of a lecture. What do you think about that? The fact that given these sort of the technological reality, these corporations are increasingly in positions to have to make decisions, legal decisions, that really should be left to the courts.
I think you're referring to one of the former heads of hate speech policy at Facebook, who wasn't one of my students, but I did interview him for the New Republic for a piece called The Delete Squad, and he did say
I apologize. All right, that was my confusion.
No trouble at all. But it's something along the lines that you suggested, that he kind of questioned the fact that he and his colleagues have this awesome responsibility, and others in his position have raised similar questions. The former head of Google, the former Associate General Counsel of Google, Nicole Wong, told me decades ago for a piece in 2007 called The Deciders that she also thought the scope of decisions that she and her colleague had to make was so great, given the 100 and some odd countries that Google does business in, that she wondered whether the companies were actually equipped to make them. Now, the fact that the companies have awesome power and are private corporations unconstrained by the Bill of Rights doesn't necessarily mean that courts are the better deciders, or even the legislators. To me, there's not a clear answer about who is best equipped to make these decisions, given the scope and the values that may be applied. But I do feel strongly that the principles of the U.S. Constitution, in particular those of the First Amendment, which has been properly construed by the court to allow the restriction of speech only when it's intended to and likely to cause imminent violence, I think that principle should be voluntarily adopted by the companies to the degree that they can. They can do that in the U.S., not so much in Europe, which has a more constricted notion of free speech. And essentially, I think we need as a society to have a vigorous national debate, as they say, about whether and how the companies should be constrained, to what degree the legislatures and courts should be involved, and how free speech values can be best protected. Now, as it happens, we're having precisely that debate. Congress and citizens are concerned about fake news and interference in Russian elections. There's pressure on Facebook and the platforms to filter fake news. The question of whether that'll take legislative form remains to be seen. But citizens around the world, as well as legislators, are aware of the power these companies face, and we're trying to figure out now how to strike the right balance.
So that kind of brings us to this question of what is the role of Congress versus the courts, right? Because this would be something that Congress would have to intervene in. Am I correct in thinking of it that way?
Yes. The question of whether it should be Congress, the courts, or neither, or regulators, or even a constitutional amendment to regulate the platforms, all of those are on the table.
Do you have any feelings on this whatsoever? I mean, do you have thoughts? Do you fall on in one perspective or another? I know that philosophically speaking, having studied your work, you believe you're very, again, Brandeis is very much sort of an icon for you. And in that, I assume it's really, you think the spirit of the amendments of the Bill of Rights is what we should be more concerned on, and not the sort of the literal language, correct?
Yes, but I mean, literal language, the First Amendment isn't self-interpreting, but I do believe that the spirit and the historic principles that Brandeis properly read into the First Amendment, which date back to Jefferson and Madison and theories of natural rights, are the correct spirit of those amendments and should be applied as much as possible by the platforms to the degree that they're adjudicating free speech. I don't have a confident feeling about the appropriate interventions by judges and legislators at the moment. In practice, I find it hard to imagine that Congress would adopt anything like First Amendment for Facebook that would require the platforms to allow speech to be restricted only when it was intended to and likely to cause imminent violence. And even if Congress were likely, hypothetically, to pass such a law, which it's not, there are questions about the speech rights of companies and the virtues of federal regulation that need to be debated as well. But I guess I believe, and I also think Facebook and Google have not so far done a decent enough job, given the alternatives of adopting something approaching the American First Amendment tradition, although they've also allowed the banning of more speech than the First Amendment would ban. But they're subject to overpowering commercial as well as political pressures that may make that less stable in the future. Over the long term of U.S. history, courts have proved to be the best defenders of the rights of minorities and of unpopular speech than any other institution. So that alone suggests that there might be some role for courts in the future, but I'm not confident enough to have a clear sense of what the right path is at the moment.
Well, you mentioned this fake news controversy, and that's something I want to ask you about as well. Fake news on the one hand, which is, I think, one particular phenomenon that we are experiencing currently under this umbrella of fake news. And the other one I want to ask you about is something that we've discussed on the show a little bit in our episode with John Borthwick, which is what he calls synthetic news. I don't know if there's an actual term for that, but it's something that's enabled by technology, which is you can actually stitch together and recreate, make someone like Barack Obama, for example, if you have plenty of sort of video footage of him and audio, you can make him say something that looks convincingly real that he in fact did not say. And that's going to be a real problem if we're going to simply just go off of things like video footage. Go to the videotape, you know what I mean? I wonder what you think about that, the challenge of sort of truth in this digital age.
Well, it's obviously a tremendous challenge, which is shaking our notions of facts to the core. And Brandeis believed that without agreement about facts, democracy would perish because citizens couldn't develop their faculties of reason and converge around a common understanding of truth. But exactly what the role of the platform should be, again, forgive me for being so tentative,
no.
But these are really tough problems, and they're just playing out before our eyes. Some are calling on the platforms to review all news that goes out under them and to label as fake news. That would represent a transformation of the way the platforms are treated legally and philosophically. At the moment, they're immune from liability for falsehoods and libel posted on them by Section 232 of the Communications Decency Act, which says that as long as the platforms don't act as editors but are merely hosts, then they're not liable for anything people post. And that's proved to be a great boon for free speech in the U.S. because the platforms don't have to censor a lot and can let 1,000 or 1,000,000 or 1 billion flowers bloom. Were they required to review everything, that would put them in the view of being newsstands rather than neutral platforms like a public park. And if they were newsstands or editors, then they'd have to exercise editorial judgments, which might lead them to overregulate. And also the question of fake news is sometimes contested. I suppose there's some stuff that's deliberately created by algorithms to be false. But in other cases, what's fake news is a matter of opinion. In fact, is a form of opinion. And that's why American law has traditionally not allowed the regulation of opinion of any kind. That was the core of the Jeffersonian belief in the definition of freedom of conscience. and therefore putting the platforms in the business of distinguishing between fact and opinion, especially given the volume, billions of pieces of content exchanged every, whatever it is, minute or hour.
All the time.
Is daunting. Yeah, all the time.
No, I mean, I absolutely, and it's a fair point. And in fact, I don't mean to put you on the spot and ask you necessarily what you think. I'm also sort of saying, well, okay, what are the opinions out there? What are some of interesting ideas around that? I think, where I fall in this, and when I talk about fake news, I don't actually mean willful deceit meant to achieve some political objective. I know that's the sort of big theme in the media, but I think what's really more troubling is the way in which content is created to target the algorithms of the social media platforms and the platforms in general in order to find a way to accelerate your content, get it on trend, and just push it out. And that's the idea of conflating cat videos with hard news. And that is a problem without question. And how to resolve it, I don't know either. It certainly is a big one. Let me ask you something that I think is easier to sort of, for both of us to discuss. It's because it's older, it's been around. And this is this notion of net neutrality. But I want to also talk about that in the context of what we were just describing, which I think of as content neutrality. Now, could you tell our audience a little bit what net neutrality is for whoever doesn't know?
Sure. Net neutrality is the principle that platforms shouldn't discriminate among content that they host and should treat content equally. So to take an example, Comcast got into trouble a few years ago when it was alleged to have discriminated against BitTorrent, which is a file-sharing network, on the grounds that it was allegedly preferring its own file-sharing service. And as a result, people had trouble downloading barbershop quartets or copies of the King James Bible on BitTorrent. So net neutrality would prohibit Facebook, or rather Comcast, from favoring its own file share over BitTorrent and would require the content to be treated equally. That's the thinnest version of net neutrality. Things get trickier when the question is, can Comcast charge more for non-affiliated platforms that use a lot of bandwidth? So Netflix takes up a lot of bandwidth. Can Comcast charge Netflix users more for downloading Netflix videos than for videos downloaded under Comcast-owned companies? That is a prohibition on price discrimination, which is a more robust version of net neutrality. But the one that the FCC has adopted, and then that's the Federal Communications Commission, and then was struck down by the courts on the grounds that the congressional authorizing statutes didn't support it, and then which the FCC tried again under a different provision, essentially was the first version, which would have prohibited platforms from discriminating among content providers and required them to treat every bit of content equally.
What you're basically saying is there's no discrimination between the bits of information, the idea that every bit is treated equally on an informational level. That would be, I think, what net neutrality is, correct?
Well, I'm hesitating only because there are all sorts of ways that we might treat different bits of information differently. I think this was really a question of, can it be blocked or slowed or degraded? Or
right,
can it be
right.
accessed as quickly as every other bit of information?
Right. The idea, for example, that if you have a VOD service, video on demand service, for example, it's a simple analogy or example I would use. If you're Time Warner and you want people to use your video on demand service, this is especially true in the earlier days, it would be in your interest to throttle Netflix because you'd rather have your customers watching your own VOD library than going to Netflix. I mean, that would be, I think, a good example. I bring it up because I think, for me, net neutrality is, I think, conceptually reaches further in the minds of people who haven't really looked at sort of what that is in legalistic terms, because of the fact that within the net itself, it brings us back to this notion of the platforms and the ability of the platforms to actually throttle traffic on a software level so that a Facebook can throttle traffic. And in fact, they do. And I've experienced this myself. In fact, I've experienced it over time, as many have, and many publishers have. There are ways in which, on a regular basis, content that exists online goes through these virtual choke points that are really sort of a parallel to the choking that would happen at the ISP level. Anyway, that was my sort of point about that. I was just curious if you had any thoughts on it. And I think it sort of ties back into this issue of the platforms and commercial power. And it's a really big deal. I mean, it's a really big deal in the current paradigm of what sort of we're facing. If you have any thoughts on it, let me know. Or we could just kind of move forward to some of the more sexier topics like designer babies.
Well, you're absolutely right that the architecture of blocking is crucial, and there are some moves to block really offensive content at the network level in Britain, bullying videos, or in the U.S., child pornography. There's pressure on the internet providers themselves, like Comcast, to identify the censored content and block it. And that would set us down a road toward putting the owners of the pipes essentially in the position of being content reviewers that could lead to some troubling consequences.
Your hesitation, I think, reveals something important, which is that these are extremely complex conversations to have. And I think so often in the sort of framing, they're framed so in such simple terms. But when you actually look at the law, could you speak a little bit about that, maybe sort of your experience with the complexity of the evolution of law in your career?
Well, of course, the technological changes in the past decade alone have been dizzying beyond imagination. And the law is always, it's a conservative force in the small c, and it moves incrementally and tries not to leap ahead of technological change, but also not to lag too far behind. But I suppose I've been struck and moderately optimistic about the willingness of judges of different backgrounds to grapple with these changes and to help translate the law into an age of new technology. The fact that the Supreme Court is unanimous or nearly so in the global positioning system case, in the cell phone on arrest search case, suggests that this is not a partisan issue, that justices of all backgrounds and judges as well can understand the importance of translating the law in light of new technologies. And although technology itself is complicated, the translation of constitutional principles, although challenging and requiring rigorous thought, doesn't require a degree in science. It requires a leap of constitutional faith, an act of creative constitutional translation of the kind that Brandeis insisted on, so that we preserve these amendments and have the same amount of privacy today as we did then. So the challenge comes not from the technological complexity, but of a lack of or presence of creativity.
Let me ask you something else. This concept, this notion of liberty and freedom, this is so central to the American Constitution and to the framing. One of the things I thought about in preparation for this interview, I saw the case of Aaron Hernandez, the tight end for the Patriots, and I thought about that because of certain things that came out after this is the gentleman who he was convicted of murder, and then he hanged himself recently in his jail cell, a very sort of tragic case. And it was later discovered that he, in fact, had damage to his brain. I don't remember what the exact term is for when you get this from football, but he was exhibiting early stage symptoms of that. And it made me think a little bit, and in fact, it may have even been talked about in the media, but I thought about how this can connect to this evolution of neuro law, right? And the way we're sort of thinking about agency and free will in the 21st century. Do you have any thoughts on this? Are there any interesting cases? Are there any interesting opinions? Have you read anything interesting around neuro law and the sort of advancements in neuropsychology and insights around free will and the way that this is changing and how this is affecting or could affect the law going forward?
It's a fascinating topic. I did a piece on neuro law for the New York Times Magazine a while ago. It was I'm just checking about the date, but it was a few years ago. And I haven't followed the field closely. It was 2007. It was quite a long time ago, called The Brain on the Stand. And I haven't followed the field closely since then. But my understanding is that the law has not dramatically evolved beyond the place it was then, which is that judges are occasionally admitting neuroscience evidence in at the sentencing stage, where any evidence is admitted under a low relevance standard, but that essentially people are not being acquitted on the basis that my brain made me do it. That was the strong claim of neuro law when it launched more than a decade ago. The idea that people who had overly active amygdalas and whose prefrontal cortexes, which is the conscience part of the brain, were underactive, might be excused on the basis that they basically had a abnormal brain. And that hasn't really flown. It hasn't persuaded juries or judges. Essentially, those juries and judges are treating neuroscience evidence just like the Twinkie defense. Ordinarily, the law doesn't care if you shot someone because you had a bad childhood or ate too many Twinkies or because your brain made me do it. You're held responsible for your freely chosen actions. And unless neuro law got to the point of calling into question the notion that we have free will itself, if it got to the point of claiming that although I think right now I'm gesturing and talking to you on the podcast, but this is just an illusion that I'm doing this intentionally, and actually I'm programmed to be moving my hand and to be speaking in the way that I am, and I'm essentially an automaton or a robot, the kind of artificial intelligence type we were talking about earlier. If that were proven by neuroscience, then that might be different, but it hasn't come close to being proven. So at the moment, judges and juries are treating this as, interesting stuff that can come in along with almost everything else, but stuff that's not at the moment dispositive.
Well, my most recent interview was with Dr. Heather Berlin, who's a neuroscientist here in New York, and this came up. And this is a very common perspective. I think it's an emerging perspective in the materialist sciences that we are moving towards this place of accepting this notion that, in fact, agency is an illusion. And it does concern me, the advancements that are happening. Again, this is a remarkably challenging field, and I say this with great humility, especially preparing for this interview, because I really wanted to think critically about how I want to take your time, because you have spent so much of your career thinking about this stuff and you've lectured on it, and I'd highly recommend to anyone who's interested to get your Great Courses series on lecture if they want to learn about the implications of constitutional law in the 21st century, in the age of technology and technological intermediation. I say it with great humility because these are very complex ideas, and the notion that they would pervade the courts is something that we should consider. And we talk about all these technologies and these scientific advancements on this show, and we've never really talked about the legal implications and how would the law deal with them. And I think, again, preparing for this interview and thinking about that really brought some humility to me in that respect. What about, for example, the innovations and the advancements in the genomic sciences and genetic engineering? I mean, what have you heard? Is there anything interesting in that field that, legal scholars are discussing?
Well, there were some great papers in that Constitution 3.0 book, and again, this was published a while ago, about how notions of genetic engineering are challenging ideas of human autonomy. So there are efforts to create designer babies, and couples wanting to select or not select when they're creating embryos through in vitro fertilization in favor of height or eye color or sexual orientation or whatnot. And the question is that constrained by the Constitution? Well, the one side, the strong autonomy side says that if the court in Roe v. Wade and associated cases said that we have a autonomy right rooted in the Liberty Clause of the 14th Amendment to choose to procreate or not, then we have the right to choose what kind of children we want to create in the course of our procreation, and therefore our ability to create designer babies should be unconstrained. The other side says if the fertilized embryo, is a human being with full constitutional rights under the 14th Amendment, then any attempt to engage in genetic engineering or even stem cell research itself could be murder and could be published as such. And I guess, unsurprisingly, many people fall somewhere in the middle and are unwilling to accept either of those extremes and might feel that perhaps the Constitution, at least in its current form, may not regulate designer babies or genetic engineering, but perhaps there should be statutes or ethics boards, as there are in Europe, where the British Parliament and many of the French and German governments have set up bodies of experts to establish principles for genetic engineering based on, for example, principles that selection on the basis of therapy is more morally, ethically, and perhaps legally acceptable than efforts to enhance embryos on the basis of particular characteristics. But these are just some initial thoughts, and the field is in its infancy.
Well, it's great that you bring up Europe, because one of the, I don't know if it's a law. Is it a law, the right to be forgotten? I don't know how you would refer to it, but I learned about this from reading your work. It shows a distinction between the way in which the Europeans deal with privacy, for example, and the way in which the Americans do. What are some of the distinctions between the way in which European courts have dealt with these questions and the way in which American courts have that you think is interesting?
Well, the right to be forgotten is definitely the most dramatic and I think perhaps the most significant difference. The European Court of Justice a few years ago recognized this broad right to be forgotten on the internet, which says that in Europe, any European data subject has the right to demand the deletion of any irrelevant or outdated data. In practice, this means that anyone in Europe, if we were in Europe talking and someone tweeted, Jeff is boring or the interview's gone long enough, then I could demand, or you could demand, that this scurrilous tweet be deleted by Google as irrelevant, and then Google would have to decide if you or I are public figures and if the tweet is in the public interest. And if they guess wrong and a privacy commissioner in Europe over second guesses them, then Google is liable to up to 2% of its annual income, which last year was $60 billion per incident. So that kind of fine focuses the mind, and Google has removed 43% of the takedown requests it's received in Europe, including requests to take down articles about the right to be forgotten itself. And none of this could happen in the U.S., where we believe that the publication of truthful but embarrassing information cannot be restrained unless it's intended to and likely to cause imminent violence, back to Brandeis. So a huge difference between the way the Europeans deal with privacy, rooted in notions of dignity and honor, and the way the American courts do, rooted in notions of liberty.
Professor Rosen, I appreciate you lending us so much of your time. I want to ask you one more question before I let you go, and that has to do with, let me ask you, do you still teach? You teach right now, correct?
I'm on leave from GW Law School, so I can run this wonderful institution, the National Constitution Center.
I wasn't sure if you also taught on the side. Then this is what I wanted to ask you. When you did teach, and certainly you do teach in a way, right, by doing these interviews and lecturing, what is the single most, or a couple of the most important things that you want people to understand and take away about the law? Because you do speak so passionately about it, and that's so obvious. That does come through. And I'm curious, what is most important to you that people understand? What should the audience sort of understand about our conversation today?
Well, thank you for asking. It is important, and I am passionate about it. And the most important distinction that I try to teach law students, and now try to inspire citizens of all backgrounds with, is the importance of separating your political from your constitutional views. All of us have political views, and we're unlikely to convince each other about them. But there's a difference between our views about good policy and what the Constitution allows or prohibits. There's a difference between what the government should do, in our view, and what it may do according to the Constitution. So by asking not, is ubiquitous surveillance by drones in public a good or bad idea, but does the Fourth Amendment allow it or prohibit it, then citizens and listeners to this podcast will have to learn enough about the text and history of the Fourth Amendment and Supreme Court cases interpreting it and new technologies that challenge these interpretations to have an informed constitutional view. And you might find yourself having your political and your constitutional views diverging, thinking that ubiquitous surveillance or the kind of technologies we're talking about are really bad ideas, but the Fourth Amendment allows them, or conversely, that they're good ideas, but the Fourth Amendment prohibits them. And there's something so rigorous and important about that distinction, both because it forces us to learn and to cultivate our faculties of reason, to take the time to learn enough about these important provisions to make an educated decision, and also because it lifts us above our partisan political views and allows us to both unite around and debate this great document of human freedom which unites us, which is the U.S. Constitution.
I love that. I felt the same way reading it. It gave me such a tremendous appreciation for the law that I did not have before. So, Professor Rosen, thank you again so much for your time. And audience, I want you all to know there's going to be, as always, there are going to be links to reading materials, but I'm also going to put a link up to the Great Courses series, which I think is sort of the easiest way to really, to use a metaphor that's appropriate to today, to download so much of what Professor Rosen has done, as well as his this book that he edited, Constitutional Law 3.0. Professor Rosen, thank you again so much for your time.
Thank you for a great conversation.
And that was my episode with Jeffrey Rosen. I want to thank Professor Rosen for being on my program. Today's episode was produced by me and edited by Stylianos Nicolaou. Sound engineering is also Stylianos Nicolaou. For more episodes, you can check out our website at hiddenforcespod.com. Join the conversation through Facebook, Twitter, and Instagram at Hidden Forces Pod, or send me an email at dk@hiddenforcespod.com. Thanks for listening. We'll see you next week.